good morning. Today we are going to deal with a very important provision in the Constitution and an important area in the Constitution, namely the preamble of the Indian Constitution. As you are aware, the preamble is an area from which we get questions regularly in the examinations. And it's also very important with reference to the Constitution. Now, before coming to the preamble of the Constitution, let us understand what is a preamble. You know, for every statute, there is a preamble. എല്ലാ നിയമങ്ങൾക്കും ഒരു preamble ഉണ്ട്. So, preamble of a statute is the introductory or opening words of a statute. ഒരു നിയമത്തിന്റെ ആമുഖമായി പറയുന്ന കാര്യങ്ങളെയാണ് നമ്മൾ preamble എന്ന് പറയുന്നത്. അത് എല്ലാ നിയമങ്ങൾക്കും ഉണ്ട്. Now, preamble of a statute precedes the enacting part or the operative part of a statute. It happens before the section 1 of a statute starts. ഒരു നിയമത്തിന്റെ സെക്ഷൻ 1 അല്ലെങ്കിൽ ആർട്ടിക്കിൾ 1 തുടങ്ങുന്നതിന് മുമ്പ് തന്നെയാണ് ഈ പ്രിയാമ്പിൾ കൊടുത്തിരിക്കുന്നത്. അപ്പോൾ ഒരു ആമുഖമായാണ് കൊടുത്തിരിക്കുന്നത്. Now, preamble of a statute is very important because it throws light to the intention of the makers of a statute. That is, the objective of the preamble is to give a bird's eye view or an overview on what is inside a statute. What was the intention of the makers of a statute? ഒരു നിയമം നിർമ്മിച്ചവരുടെ ആ നിയമത്തിനെ കുറിച്ചുള്ള സങ്കല്പങ്ങളാണ് പ്രിയാമ്പിളിൽ പറഞ്ഞിരിക്കുന്നത്. സോ അത് വളരെ പ്രധാനപ്പെട്ടതാണ്. ഒരു ഓവർവ്യൂ ഒരു സ്റ്റാറ്റ്യൂട്ടിനെ കുറിച്ച് നൽകുന്നതാണ് preamble. Now we come to preamble of the Indian Constitution. Now, with regard to preamble of the Indian Constitution, it's so important that in many constitutional cases, the preamble was referred to by the courts. So it's very important. Now, how the preamble of the Constitution goes. I am not going to reproduce the preamble, but I will give the content of the preamble. So, the preamble, I told you, precedes the Article 1 of the Constitution. ഭരണഘടനയുടെ ഒന്നാം അനുച്ഛേദം തുടങ്ങുന്നതിന് മുമ്പ് പറയുന്നതാണ് preamble എന്ന് പറയുന്നത്. In preamble, it goes like this. We, the people of India, having solemnly resolved to form this, to constitute India into a sovereign, socialist, democratic, and secular republic, and to secure to all Indians justice, equality, liberty, fraternity, adopt and enact and give to ourselves this Constitution. So this is how the preamble is worded. So the preamble declares India to be a sovereign, socialist, secular, democratic republic. It also says that we have given this Constitution to ourselves. And further, this preamble is created by the people themselves. ജനങ്ങൾ തന്നെയാണ് ഈ ഭരണഘടന ഉണ്ടാക്കിയിരിക്കുന്നത്. ജനങ്ങൾ സ്വമേധയാ സ്വന്തമായി തന്നെ കൊടുത്തിരിക്കുന്നത് അല്ലെങ്കിൽ നൽകിയിരിക്കുന്നതാണ് ഈ ഭരണഘടന. This is the intention of the wordings of the preamble. Now, let's come to the importance of the preamble when you interpret Constitution. In a case, Barbar Union, which we will be dealing in detail later, the Supreme Court of India had held that preamble is so important that preamble is the key to open the mind of the makers of the Constitution. Preamble is the key to open the mind of the makers of the Constitution. That is, if you want to get the idea with regard to which the Constitution was framed or the idea of each and every section of the Constitution, what the makers of the Constitution, the Constituent Assembly intended, we can use the preamble. That is, preamble is the key to open the mind of the makers of the Constitution. ഭരണഘടനയുടെ ശില്പികളുടെ മനസ്സ് തുറക്കുന്ന താക്കോലാണ് നമ്മുടെ preamble. In another case, the court have held that preamble is the heart and soul of the Constitution, the soul and spirit of the Constitution. So some other person had said that preamble is a window to the Constitution. What is the purpose of the window? If you look into the window, you can get an overview of the room. You can see what is inside or what is the content of a room. So preamble is like a window. You open it and you can see the Constitution. So these are certain references with regard to the preamble, which shows the importance of the preamble. Now we analyze the wordings used in the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Now, when the constitution was made, at the onset, the word secular and socialist was not there. It was only a sovereign, democratic republic. തുടങ്ങുന്ന സമയത്ത് പ്രിയാമ്പിളിന്റെ 3 വാക്കുകളെ ഉണ്ടായിരുന്നുള്ളൂ. Sovereign, democratic republic. Now the word secular and the word socialist was later added. Now what is the change made by that? That was added by the 42nd Amendment. It was added by the 42nd Amendment when I think Mrs. Gandhi was in power. Now the question is, what is the effect of this amendment? Was India not a secular state? Was India not a socialist state before the passing of the amendment? Nothing like that. It is very evident that even before the amendments, India was a secular country and India was a socialist country. Because the concept of secularism is throughout there. Or it is like there is a brooding omnipresence of secularism throughout different articles of the Constitution. The power of the minorities, religious freedom, and all these things. Sections 25, 26, 27, 28, 9, all these embodies the spirit of secularism. And similarly, Indian Constitution, even before the amendment, was a socialist state. Because in the preamble itself, it guarantees that there shall be justice, economic. So justice, economic justice means it's a form of socialistic temperament. Then 39B and C of the Indian Directive Principles clearly prove that in India we aim at creating an equitable distribution of wealth. So the concept that India was a socialist state even before the amendment. Only thing the amendments did was to make it very obvious what existed earlier. That's all. Now let's analyze one by one what are the things which are included in the preamble. India is first content is that India is a sovereign country. Now, what do you mean by sovereignty? Sovereignty means India is not under the yoke or control of any other power. The government of India is a supreme power as regards to people of India, and there is no other body which is above the Indian constitution or Indian government. This is the implication of the word sovereignty. Just because India is a part of the Commonwealth doesn't mean that the British Parliament or anyone has a particular control over the Indian polity or governance. Just like the British India, which was controlled by the British Parliament. Nothing like that exists now. So this is the implication of the term sovereignty. The second concept is India is a sovereign secular. Now, secularism. What do you mean by India is a secular country? India is a secular country doesn't mean that we are against religion. Indian secularism implies that we don't have a state religion. Indian secularism എന്ന് പറഞ്ഞാൽ നമ്മൾ മതങ്ങൾക്ക് എതിരാണെന്നുള്ള അർത്ഥമല്ല. നമ്മൾ പറയുന്നത് നമുക്കൊരു സ്റ്റേറ്റ് മതമില്ല. Just like you have the Islam for the Pakistan or some other countries, for the Vatican, the Christianity. Similarly, India or the country treats every religion equally. And the state won't interfere in the matters of religion and will not allow religion to interfere in the matters of polity. Indian secularism എന്ന് പറയുന്നത് നമ്മൾ ഒരു മതത്തിനും എതിര്, പക്ഷേ മതവും രാഷ്ട്രീയവും മാറി നിൽക്കണം. രാഷ്ട്രീയത്തിന് മതത്തിലോട്ടോ മതത്തിന് രാഷ്ട്രീയത്തിലോട്ടോ ഒരു പ്രവേശനമോ ഒരു കാര്യമോ ഇല്ല. We are not against religion. We have equal, we stand detached from all religion. And we also have the same attitude with regard to persons who don't believe in religion. അപ്പോൾ ഇന്ത്യയിൽ എല്ലാ മതങ്ങളും തുല്യതയാണ്, എല്ലാ മതങ്ങളോടും ഒരു തുല്യതയാണ് സ്റ്റേറ്റിന്റെ ഭാഗത്തുനിന്ന്. അതേ റെസ്പെക്റ്റും അതേ പ്രാധാന്യവും മതത്തിൽ വിശ്വസിക്കാത്ത എത്തീസ്റ്റ് അവർക്കും കൊടുക്കാറുണ്ട്. സോ വി ആർ ഈക്വൽ ടുവാർഡ്സ് എവറി റിലീജിയൻ ആൻഡ് സോ ഓൾസോ ടു പേഴ്സൺ ഹു ഡസന്റ് ബിലീവ് ഇൻ എ ഗോഡ് ലൈക്ക് ദ എത്തിസ്റ്റ്. So secularism is a very important concept, and in cases like S.R. Bommai, the Supreme Court have held that secularism is a part of the basic structure of the Indian Constitution. Then we are a democratic republic. A democratic republic implies that, democracy, the conservative, the classic definition, democracy means the rule of demos plus cracy, the rule of the people. Janadhipatyam, ജനങ്ങളുടെ ആധിപത്യം, that is democracy. So, what is the democracy in India? There are different forms of democracy, direct and indirect. Of course, there is no direct democracy. That existed only during the Greek in the early period. We have an indirect democracy everywhere in the world. In indirect democracies itself, there are different categories. One is that is adopted in America, that is a presidential democracy. But here we have adopted what you call the parliamentary form, where the parliament is the supreme authority. And the real executive power is the prime minister in council. But Indian democracy എന്ന് പറയുന്നത് ഒരു പാർലമെന്ററി ഡെമോക്രസിയാണ്. ആ പാർലമെന്ററി ഡെമോക്രസിയിൽ യഥാർത്ഥ അധികാരം പ്രൈം മിനിസ്റ്ററും കൗൺസിലിനും. അമേരിക്ക പോലുള്ള രാജ്യങ്ങളിൽ ഇറ്റ് ഇസ് പ്രസിഡൻഷ്യൽ ഡെമോക്രസി. പ്രസിഡന്റ് ഇസ് ദ സുപ്രീം അതോറിറ്റി. Now, then again the preamble says that we are a socialist republic. As I told you earlier, socialism is a state where there is equitable distribution of wealth. And India has adopted a socialist republic, that is made obvious in the preamble. But Indian socialism, many have argued it is different from the communist socialism. Our socialism is claimed by many persons as a democratic socialism based on the principles of Nehruvian socialism and the ideas of our father of the nation, Gandhi. So whatever it is very evident that we have a socialist form of government. Whatever may be the type of socialism which we are adopting in this welfare state. Because we know that we are a welfare state right now, which aims at the welfare of the people. So these are the main contents of the Indian preamble. Now with regard to preamble, there are two fundamental or basic aspects which has given rise to several cases. or two very important cases, or two very important points. Preamble സംബന്ധിച്ച് മുഖ്യമായ രണ്ട് ചോദ്യങ്ങൾ അല്ലെങ്കിൽ രണ്ട് പോയിന്റ്സ് ആണ് ഉള്ളത്. Point number 1, whether preamble is a part of the constitution. ആദ്യത്തെ ചോദ്യം, preamble ഭരണഘടനയുടെ ഭാഗമാണോ? Preamble is a part of the constitution. Is preamble a part of the constitution? First question. The second question is whether the preamble can be amended. Whether the preamble can be amended. These are the two questions. So we'll be dealing both the questions together because they were answered by the same cases. ഈ രണ്ട് ഭാഗവും ഈ രണ്ട് പോയിന്റും ഒരേ ടൈപ്പുള്ള രണ്ട് കേസുകളാണ് തീരുമാനിച്ചത്. അതുകൊണ്ട് നമുക്കത് ഒരുമിച്ച് രണ്ട് കേസായിട്ട് പഠിക്കാം. So the question whether preamble is a part of the constitution, the question whether preamble can be amended was decided in two famous cases, very famous constitutional cases. The first one is in re Berubari Union. In re Berubari Union. Second case is the most famous case in constitutional law, or the whole law of the Indian, whole law with regard to Indian jurisprudence, that is the Keshavananda Bharati versus State of Kerala. Now we come to the first case, in re Berubari Union. Now here, let's analyze the facts. The facts are like this. You know, a state can, or a state may, give its territory to another country. That is, if a state is giving away its territory to another country, this process is called by the name ceding of a territory, CEDING, or cession. ഒരു രാജ്യം മറ്റൊരു രാജ്യത്തിന് അതിൻ്റെ സ്ഥലങ്ങൾ, അതിൻ്റെ ഭാഗം കൊടുക്കുന്നതിനെയാണ് നമ്മൾ സീഡിംഗ് ഓഫ് എ ടെറിട്ടറി എന്ന് പറയുന്നത്. The government of India ceded a portion of India called the Berubari Union to the then Pakistan. That is, during that time, East Bengal, today's Bangladesh, was also part of Pakistan. So certain territory called Berubari Union was ceded by India to Pakistan. When the territory was ceded, there was a revolt and upheaval in that territory because the people there never wanted to go to Pakistan. They wanted to remain in India. So they were against this ceding of the territory. There were riots and all these things. There were contentions for the government and against the government. And the president, I think, referred this matter to the Supreme Court for its opinion. And thus this came before the Supreme Court of India. അപ്പോൾ ഇന്ത്യ ഗവൺമെന്റ് കുറെ സ്ഥലങ്ങൾ ബെർബാറി യൂണിയൻ എന്ന് പറയുന്ന സ്ഥലം പാകിസ്ഥാന് കൊടുത്തു. അവിടുത്തെ ജനങ്ങൾ അതിനെതിരായിരുന്നു. അവര് പ്രക്ഷോഭം തുടങ്ങി. ഈ തർക്കം ഉണ്ടായപ്പോൾ പ്രസിഡന്റ് ഈ കേസ് സുപ്രീം കോർട്ടിന് റെഫർ ചെയ്തു. Now when it came to the Supreme Court, main contention on the opposite side, that is the side against the government, main contentions was the government or the state does not have the power to cede a territory to another country, because under the constitution the sovereign of the state is the people. Because in the constitution itself it stated that we have enacted and adopted and give to ourselves this constitution. We have enacted and adopted and give to ourselves this constitution. And in the first passage it stated having resolved to create or constitute India. അപ്പോൾ നമ്മുടെ പ്രിയാമ്പിൾ എടുത്താൽ അതിനകത്ത് തന്നെ പറയുന്നുണ്ട്, ഈ ഭരണഘടന ജനങ്ങൾക്കായിട്ട് കൊടുത്തതാണ്. സോ the real sovereign of the country, രാജ്യത്തിന്റെ പരമാധികാരി ജനങ്ങളാണ്. So only as the people are the sovereign of this country, only people can cede the territory, and the governments or the parliament cannot cede territory. This was the contention. Because by the preamble, the real sovereigns of the country are the people. പരമാധികാരി പ്രിയാമ്പിൾ വഴി ജനങ്ങളായതുകൊണ്ട് ജനങ്ങൾക്ക് മാത്രമേ രാജ്യത്തിനെ മറ്റൊരു രാജ്യത്തിന് കൊടുക്കാൻ പറ്റുള്ളൂ. അത് പാർലമെന്റിനോ എക്സിക്യൂട്ടീവിനോ ഒന്നും ചെയ്യാൻ പാടില്ല. ദിസ് വാസ് ദി കണ്ടൻഷൻ. Now in this case, the contenders relied on preamble. Now from opposite side, that is from the side of the government, it was contended that preamble is not a part of the constitution and preamble cannot be used to interpret the constitution. Preamble is not a part of the constitution and preamble cannot be used to interpret the constitution. അപ്പോൾ ഭരണഘടന ഇന്റർപ്രറ്റ് ചെയ്യാനായിട്ട് പ്രിയാമ്പിൾ ഒന്നും നോക്കാൻ പാടില്ല. പ്രിയാമ്പിൾ ഇസ് നോട്ട് എ പാർട്ട് ഓഫ് ദി കോൺസ്റ്റിറ്റ്യൂഷൻ. Now the dispute before the court was whether preamble is a part of the constitution. As we said earlier, preamble is like a window to the constitution. So the question is again whether window is inside the room or outside the room. ഒരു ജനൽ പോലെയാണ് പ്രിയാമ്പിള്. അപ്പൊ ജനല് മുറിക്കകത്താണോ പുറത്താണോ? Now the thing is that a preamble is certain statements made before the section 1 of an article 1 or a section 1 of a statute starts. So whether it is inside the statute or outside the statute. And in Berubara Union, the Supreme Court came to the conclusion that preamble is not a part of the constitution and therefore it is having only a limited role with regard to interpretation of the constitution. Only if there is a doubt with regard to the ambiguity with regard to a section, it can be referred to. Preamble ഭരണഘടനയുടെ ഭാഗമൊന്നുമില്ല. അതുകൊണ്ട് ഒരു സെക്ഷനിൽ സംശയം വല്ലതും വന്നാൽ ഒന്ന് നോക്കാവുന്നുള്ളതേ ഉള്ളൂ. This was the attitude of the court. Now, the second case with regard to the preamble, which happened many years after, was the what do you call the epic case, or such a monumental case of Keshavananda Bharati versus State of Kerala. So Keshavananda Bharati case has so many other aspects. This was a case which was decided by the 13-member bench, the biggest constituted bench in India. I think I'm not very sure, possibly. So Keshavananda Bharati had to deal with so many aspects, like whether fundamental rights can be amended, whether basic structure can be altered, whether 13 includes law and amendment. So many issues were there in Keshavananda Bharati. But one small issue was whether preamble is a part of the constitution and preamble can be amended. Now, how did it come? You know that by 42nd Amendment, 2 words were amended and added into the preamble. What were the words? They were secularism and socialism. They were amended and included in the 42nd Amendment. 42nd Amendment-ൽ 2 വാക്കുകൾ നമ്മുടെ പ്രിയാമ്പിളിനകത്ത് അമെൻഡ് ചെയ്ത് ചേർത്തു, സോഷ്യലിസവും സെക്യുലറിസവും. Then how did the parliament amend the preamble? The parliament amended the preamble. You may be hearing some noise. So we are having a monsoon season and all thunder is coming. We can expect a rain afterwards. So leave that. Now the thing was, when 2 words were amended and added in the constitution, they were added according to Article 368 of the Constitution. The amendment adding 2 words were made under Article 368 of the Constitution. And Article 368 deals with provisions with regard to amendment of the Constitution. ഭരണഘടന അമെൻഡ് ചെയ്യുന്ന പ്രൊവിഷനാണ് 368. ആ പ്രൊവിഷൻ വഴിയാണ് പ്രിയാമ്പിളിൽ 2 വാക്കുകൾ അമെൻഡ് ചെയ്ത് ചേർത്തത്. Now a question came. In Berbera Union, it was held that preamble is not a part of the Constitution. If preamble is not a part of the Constitution, how can you amend preamble according to the provisions of the Constitution providing for amendment of the Constitution? Preamble ഭരണഘടനയുടെ ഭാഗമല്ലെങ്കിൽ ഭരണഘടന അമെൻഡ് ചെയ്യാനുള്ള പ്രൊവിഷൻ വെച്ച് എങ്ങനെ preamble അമെൻഡ് ചെയ്യാൻ പറ്റും? ചോദ്യമല്ലേ? നേരത്തെ വിധി വെച്ച് നോക്കുകയാണെങ്കിൽ ശരിയല്ലേ? ഓക്കെ, സോ ദിസ് വാസ് ദ ക്വസ്റ്റ്യൻ ബിഫോർ ദ കോർട്ട്. Now, when this issue came before the Supreme Court reversed it. ഈ ചോദ്യം വന്നപ്പോൾ സുപ്രീം കോർട്ട് നമ്മുടെ സാധാരണ ഭാഷയിൽ പറഞ്ഞ പ്ലേറ്റ് മറിച്ചു. You know what the Supreme Court held? Supreme Court held that preamble is a part of the Constitution and preamble can be amended. And it can be amended according to Article 368 of the Constitution itself. So, there are 2 differing opinions with regard to whether preamble was amended. But the reason given was, now the courts in the Keshavananda Bharati case held that there is a difference between preamble of other statutes and preamble of the Constitution. Preamble of the other statutes are not enacted by the legislature, whereas preamble of the Constitution was enacted by the Constituent Assembly as a final provision. So the very members who enacted the Constitution enacted preamble also. This difference was not noted in the Preamble Union case. So that is why that mistake came. Keshavananda Bharatiye നമുക്ക് തിരിച്ചൊന്നും പറയാൻ പറ്റത്തില്ല, because it is decided by we cannot go against the decision of Keshavananda Bharati decided by 13-member bench. Keshavananda Bharati പറഞ്ഞത് ബാക്കിയുള്ള നിയമങ്ങളുടെ പ്രിയാമ്പിള് നിയമസഭകൾ ഇനാക്ട് ചെയ്യുന്നതല്ല, എന്നാൽ ഭരണഘടനയുടെ പ്രിയാമ്പിള് കോൺസ്റ്റിറ്റ്യൂവന്റ് അസംബ്ലി ഇനാക്ട് ചെയ്തു. അതായത് അവരെല്ലാം ചേർന്നതല്ല, പാസ്സാക്കിയെടുത്തതാണ്. ഈ ഒരു പ്രാധാന്യം ആദ്യത്തെ കേസിൽ നോട്ട് ചെയ്തില്ല. So as per the existing law, we can say that Indian Constitution preamble is very important and the Indian Constitution preamble is a part of the Indian Constitution and also it can be amended. As we know that in S.R. Bombay case, the Supreme Court had held that secularism embodied in the preamble is a part of the basic structure of the Constitution. And later in another case called State versus Dinanath, the Supreme Court again held that preamble of the Indian Constitution, the whole of the preamble of the Indian Constitution is part of the basic structure of the Indian Constitution. So my friends, preamble is very important. It sheds light on to the content of the Constitution and it shows importance. It shows the importance of different aspects like economic security, economic justice, equality, fraternity. Further, it embodies the spirit of secularism and socialism throughout the Constitution. So thank you very much.